Ripple's lawyers have reacted to the Securities and Exchange Commission after the SEC declined to allow them to explore whether SEC staff were permitted to purchase XRP while the SEC was investigating Ripple for securities fraud. Were any groundbreaking discoveries made? Will this have a significant impact on the entire situation? So, tune in to find out. XRP Army. Welcome, let's help the XRP Hut community develop by liking and subscribing. Ripple's motion to compel the SEC to provide detailed responses to its interrogatories was met with a letter from the SEC. The plaintiff alleged that the defendants waited more than 7 weeks after receiving the SEC initial interrogatory responses before notifying the SEC that the responses were flawed. The SEC claims to have updated 5 of the responses in question, met with and talked with defendants, and asked them what precise material they still need. Defendants refused, filing the motion less than 3 hours before the conclusion of fact discovery. The agency has substantively answered the interrogatories at issue, according to the Federal Rules of Civil Procedure. According to a recent court order, a party, it is not necessary to catalog every fact or piece of evidence as long as representative samples are identified and meaningful disclosure is provided. The defendant's position here boils down to a complaint that they don't like the answers they received to the relevant interrogatories, in part because the SEC and the defendants have differing views of the applicable law. The SEC, on the other hand, is not required to respond to the interrogatories in a way that accepts defendants' wrong understanding of the law. The plaintiff stated in the letter that Judge Torres should address the parties' disagreement over how the relevant legal principles should be applied at summary judgment, not on a move to compel interrogatory responses. Ripple's interrogatories focus on the SEC hypothesis of how the Howey test applies to virtually all of defendants' XRP transactions over the prior 8 years. The XRP Ledger's architect filed an application to compel a few days after the widely publicized phone conference, which resulted in the judge being unimpressed with the SEC arguments and seeking an in-camera inspection of the materials the SEC claims privilege over. This initiative, like many others before it, seeks to strengthen Ripple's claim that the SEC failed to provide proper notice that XRP may be classified as a security and hence subject to the regulator's authority. Many experts are skeptical that the Howey test can be used to determine the nature of digital assets because the emergent asset class appears to operate under fundamentally different rules. While SEC Chair Gary Gensler claims that Howey is working for crypto, a number of experts, including those at Rutgers Law School and the American Enterprise Institute, have suggested that digital assets necessitate a different approach. The SEC v. Ripple case may pose the most severe threat to the Howey test validity. The banking watchdog earlier warned the court that a Ripple victory on the fair notice defense would render it useless. As a result, many legal professionals acquainted with the XRP legal battle believe that a Ripple victory on summary judgment on that defense might save the industry from the SEC. According to the defendants, the agency provided inadequate or illegal responses to several queries submitted by Ripple and Chris Larsen. Ripple's decision to compel responses to interrogatories was recently examined by attorneys Jeremy and Thien Vu Hogan. The pro-XRP camp said that the pleading is critical, stating that the SEC will write under oath, which will have a formal consequence and cannot be ignored, similar to Hinman's 2018 statement. What we can see here in Ripple's move to compel responses or better answers to its interrogatories is the SEC lawyers really struggled to set out the totality of its case with any precision, Mr. Hogan says in a video. Let us now examine the evidence that XRP was provided as a security. These public remarks included, but were not limited to, promises to and discussions of Ripple's own incentives and goals to create an active and liquid trading market for XRP, as well as to promote and foster XRP uses. Incentives for Ripple and its affiliates, agents, and executives to establish an ecosystem that used XRP and to be good stewards of XRP. Ripple's considerable XRP holdings and their connections to the company's financial operations. Ripple's and its affiliates, agents, and executives' actual attempts to stimulate demand for XRP and comments boasting the price increase of XRP and its availability on digital asset trading platforms. These and similar statements were made, among other places, in YouTube videos, tweets, and posts on digital asset discussion forum by Ripple employees David Schwartz, Patrick Griffin, Arthur Brito, Breen Madigan, Monica Long, Ashish Birla, Miel Vyas, and defendants Garlinghouse and Larson. The many other Ripple employees made such public statements. Furthermore, the economic reality: one, Ripple's XRP holdings, Ripple's XRP incentives, Ripple's XRP offers and sales, including, on occasion, at a discount to market prices, the absence of applications for XRP. In Ripple's Case 120 CV 10832 attest document 326-1, the file dates /31/21, page 11 of 3111 commitments to establish uses for XRP, and of 2 XRP itself and its relationship to Ripple, all of which induced a reasonable expectation of benefit in XRP purchasers. According to the SEC, Ripple was involved in the formation of a liquid XRP market. We believe we can all see why it would do so. Its XRP use case needs a liquid market. Ripple has also committed to developing uses for XRP. Second, Ripple allegedly attempted to rig the XRP price. Ripple, as we all know, failed in its endeavor. Ripple's actions have never appeared to have a substantial impact on the price of XRP, but the point is that it made an attempt. The SEC also cites specific individuals who sought to manipulate the market using Twitter and YouTube. Consider what has happened since the motion was filed. Finally, the SEC alleges that XRP has no utility and that buyers were expecting Ripple to discover uses for it, raising its value. So there you have it. Now, let's take a look at how XRP was performing on September 9th. The 4-hour chart of XRP price action indicates that the decline will continue. Ripple, on the other hand, is experiencing substantial price movement, which may extend throughout tomorrow's trading day. All 3 oscillator levels for XRP are highly oversold. The Relative Strength Index, RSI, has recovered from the midpoint between 2 oversold levels in a bear market, 20 and 30. The Composite Index has also recovered well. Note that the current low for the Composite Index is the lowest low for 2021 on the 4-hour chart. This could be a warning indication of further downward pressure to come. Finally, the Optex bands line fell to its lowest point, followed by a significant response bounce. The rise is expected to provide some momentum for XRP to go towards the $1.14 to $1.17 value ranges inhabited by the Tenkan-sen, $1.14, and Kijun-sen at $1.17. In such situation, the RSI for XRP will almost certainly be trading at one of the overbought levels typical in a bear market, 55 or 65. Likewise, the Optex bands will be trading overbought. Bears should keep a watch on the XRP price, whether it reaches the $1.17 value range or remains near the $1.10 level, because further declines would be accelerated if XRP falls below the most recent swing low at $1.01. The objective zone for bears is a confluence zone of the 38.2% Fibonacci retracement and the 100% Fibonacci expansion level, both at 84 cents. Bears should watch for an increase in the number of XRP bulls prepared to set off a bear trap. Within the Ichimoku system, a comeback to $1.22 would return XRP to a strong bullish state. Do you plan to invest in XRP? If you want to learn more about XRP, there are 2 more videos on the end screen for you to watch. Please subscribe to our channel and give us a thumbs up. Thank you for viewing, and I'll see you in the future video. Before you go, please keep in mind that cryptocurrency prices change rapidly. So by the time you see this video, it may have changed to a completely different value. This video's material does not constitute investment advice, financial advice, trading advice, or any other type of advice, and you should not treat it as such. The information in this video is provided solely for educational purposes and should not be construed as financial advice. Before making any investment decisions, complete your own due diligence and talk with your financial advisor.